I am John Murdock with the Nashville office of Bradley Arant, Boult, Cummings. These slides are a recap of a presentation given to a joint meeting of the IP Finance Subcommittee and the Model IP Security Agreement Task Force, which is known as the MIPSA Task Force, at the ABA annual meeting in San Francisco. These slides and the related survey are intended to make it easy to participate in the task force. Please complete the survey and pass these materials along to other lawyers with an interest in IP security agreements. At our San Francisco meeting, the group defined its goal as the creation of a model IP security agreement for a commercial transaction that involves only United States collateral, that's written in plain English, and that is as brief as can serve its purpose. Next, we consider briefly the methodology by which the Model IP Security Agreement might be created. Bar associations, law firms, and clients all recognize the value of thoughtfully vetted model documents. As a result, the methods of creating model documents have been the subject of increasing study, and most recently in a manner that parallels the growing business discipline of analytics. I call the resulting legal discipline documentary analytics, and it includes two important themes. First, the decomposition of tasks for analysis, which is a top-down process, and second, the use of digital data mining methods to survey the market, which is a bottom-up process. The decomposition of a task is a top-down process that elicits the elements of the task so they can be better analyzed and managed. Any task can be broken down in this way. For example, the construction of a house can be broken down into its various elements for pricing, contracting, and scheduling purposes. In project management terms, the diagram of a project is called a work breakdown structure, and it defines the complete scope of work to be done in a project. The work to be done by a document can also be broken down into sets of elements. This work breakdown structure of an IP security agreement divides the document's work into 7 elements. Some elements are classes that define their sub-elements, such as the class of remedies and the class of general provisions. Other elements themselves indicate a legal consequence, such as grant of security interest. Borrowing from formal logic, we can call these more specific elements of the work breakdown structure, the ones that denote a particular legal consequence, propositions. In logic, a proposition is a notion that is independent of the sentence that expresses it. The statement "a rose is red" may be said in many languages and in different ways within the languages, but each sentence stands for the same logical proposition. In drafting legal documents, the same point or proposition may be expressed in many ways that are logically equivalent. By first focusing on the point of the parts of a document using a work breakdown structure, rather than starting with a review of the exact words of a particular form, we can clearly define the document's work before entertaining issues of style. The MIPSA task force will progressively break these 7 elements down into smaller ones and analyze them. We will begin our analysis by examining the grant element. This is a further graphical decomposition of the grant element. It includes the elements that, taken together, provide the subject, verb, direct and indirect objects necessary to state a proposition of conveyance. We'll next consider in detail the way different documents express the proposition of conveyance of a security interest. In the future, we'll analyze the different ways documents define debtor, secured party, collateral, and obligations. We now consider different ways the conveyance proposition is represented in actual sentences in the marketplace. This is a bottom-up analysis because we're comparing specific sentences to the more general requirements of the proposition. This slide shows 3 sentences that I believe are logically equivalent under Article 9. There are many other ways to state that a debtor grants lien rights and personal property collateral to the same effect. We need some method to facilitate the review of the many variations in use so we can assess which sentences are logically equivalent and which ones in fact suggest different legal propositions. If we began our MIPSA task force in the traditional way, we would solicit model documents and then compare them manually, looking for apparent market leaders and for substantive variations of interest. Comparing even a dozen documents in this way can be tedious. After process decomposition, the second big point of documentary analytics is that we use machines to enable us to analyze much larger amounts of data than we could ever review unassisted. We want to survey not a dozen documents, but a dozen documents, or even more. Kiiac software allows us to quickly evaluate large numbers of model documents for their similarities and differences. Our initial pool of documents for the MIPSA task force is 105 documents harvested from Edgar. We can easily include many more models using Kiiac now that it has been configured for this task. We greatly appreciate our partnership with Kingsley Martin of Kiiac in these efforts. This is the Kiiac screen that I used to analyze 105 grant clauses for the purpose of this presentation. The left column of the screen shows the sections into which the security agreements have been divided in our work breakdown structure. The pie icons on the left reflect the amount of variability among the 105 sample documents in the treatment of each of these sections. The more solid the pie icon, the more frequently the clause occurs in the sample set of documents. For example, the grant and rights and remedies clauses appear in all documents, while a representations and warranties clause appears only in about 60% of the samples. The middle column lists the model documents that have been evaluated. The red arrow points to a bar that is both green and red. The more green the icon, the more consistent the language of that particular document's grant clause compared to the balance of the set of grant clauses. When you select a document in the middle column, the text of its grant clause appears in the right column. This text is blacklined against a statistically determined base model. Because there are so many mechanical differences among even logically equivalent clauses, a black line created mechanically against the actual words of so many clauses would be difficult to read. Kiiac does a more intelligent marking, and its identification of differences is a good approximation of the substantive differences that a human expert reviewer would find. Its blacklining identifies common language in green text and divergent language in black underlined text. My analysis of the grant clauses of the sample documents reviewed in Kiiac revealed a number of variations that do or might represent substantive differences. This slide shows in red the most simple statement of the grant proposition. The blue words are additional words that appear in a material portion of the samples. If a blue word or phrase is in fact necessary, then it should be in our model document. Consistent with our efforts at plain English and brevity, if the words don't do anything, they should not be included. This graph shows the statistical frequency of the blue words and phrases that may or may not be necessary for use in a grant clause. For example, 13% of models state that the security interest is irrevocable, and 36% of models state that the security interest is continuing. If these provisions are necessary, they should appear in the model document we are creating and should likely appear in all security agreements. The general sense of the group in San Francisco was that these two terms are not necessary, but the discussion sent us exploring for instances where these words might make a difference. The 9 criteria in the group at the bottom of the graph all deal with the technical scope of the grant. There is inherent in a security agreement an issue about the scope of its grant. A lender would often like to obtain a security interest in all personal property of the debtor, but the scope of property covered by Article 9 is a subset of the world of all personal property. In the commercial world, there are a few types of personal property assets, such as life insurance, that are often of value but are outside the scope of Article 9. If there is intellectual property that is outside the scope of Article 9, then a lender would want to take a lien interest of whatever sort is available in that property. This might justify using additional grant words that have effect under the common law with respect to the non-UCC property. But is there any intellectual property that is beyond the scope of Article 9? No examples came to mind at the meeting. Here we see again the graph showing the statistics for the various additional words of grant. Only 15% of the documents rely upon the grant of a security interest alone, but the documents vary widely in what additional words of conveyance they use. The sense of the group in San Francisco was that these additional words of conveyance have no legal consequence, at least as to collateral within the scope of Article 9. Since we couldn't think of any IP outside the scope of Article 9, these additional words seem unnecessary. We also discussed that there is a nagging reluctance to not include language that someone somewhere may have thought had a consequence, so our job of crafting a thorough but brief document is a difficult one. Documents just tend to get bigger as drafters think of more words that might matter. A final interesting feature of grant clauses is that some remove from the scope of the grant any IP subject to a legal or contractual prohibition on assignment. "29% of our samples specifically exclude trademark intentions to use from the grant clause. 9% exclude broadly any IP whose assignment is subject to a legal restriction, and 11% exclude any IP whose assignment would breach a contract. The apparent basis for these exclusions is the concern that a grant of a security interest might impair the subject IP. If these carve-out provisions are in fact legally necessary to prevent a grant clause from doing injury to the intellectual property right covered by the security agreement, then they are equally necessary to all security agreements that grant blanket security interest in general intangibles. So this is not a small question. Before revised Article 9, security agreements often included exceptions deleting from their scope any general intangibles that were subject to a law or contract that would be contravened by the grant of the security interest. It was regarded as better to leave the property unencumbered rather than place it at risk due to the contravention of the law or contract. Section 9408 of revised Article 9 provides that the mere grant of a security interest in a general intangible will not violate a restriction of law or contract, so at least to the extent of Article 9's reach, it seems there's no longer a reason to exclude assignment-restricted property from the scope of a grant in a security agreement. Of course, Article 9 can't override a contrary federal statute. 15 U.S.C. Section 1060 prohibits the assignment of intentions to use trademarks. We are curious whether there is authority that a purported assignment as collateral actually invalidates an intention to use, or if the consequence is just that the attempted collateral assignment is ineffective. We solicit advice on this point from those attorneys who may have experience with this issue. This concluded our analysis in San Francisco. Please complete the survey that accompanies this presentation and forward this presentation and the survey link to others who might want to participate in the MIPSA task force. Visit the MIPSA kiiac database, which you might keep in mind as a practice tool when drafting IP security agreements. It is in effect just a giant clause library. You can't hurt it. For more information, visit the MIPSA homepage. Just Google MIPSA Task Force or enter the address on the screen. Thanks, and we look forward to your participation in the MIPSA Task Force.